Welcome to today's episode of Real Estate in Kenya. My name is Sarah Wahogo, CEO at Username Investment Limited. As usual, today I'm joined by our company advocate, Mr. Wanjohi Geshango. When you see Wakili here, you know we are dealing with complicated legal matters. So he will be breaking down today's topic for us, and I hope that you can enjoy the session. Karibu Wakili.
Thank you very much.
Kindly introduce yourself.
Yes, my name is Wanjohi Geshango, an advocate, and I am glad to be breaking down today's topic to viewers.
Yeah, today's topic is estate planning and succession. And I know it's widely discussed and probably many times misunderstood. So Wakili, what is estate planning?
Estate planning is the procedure whereby, or it's an arrangement that, those arrangements that you make of what will happen after your death, because death is certain. So you make arrangements on what will happen to your properties, how will be your children, your spouse, your parents be provided for when you die, and who will take up your responsibilities in fulfilling those obligations, or taking care of your properties, your assets, settling your debts, and taking care of your beneficiaries.
And what is succession?
Succession now is the legal process of transferring your assets to those who are entitled to those properties. So succession means that you have to have a procedure whereby you go to court, and then it is determined who is entitled to what property, and then thereafter those properties are transferred to those who are entitled to them.
So how does the procedure of succession look like?
The procedure, there are two types of procedures. There is intestate succession, and there is tested succession. Intestate succession refers to where you have no written will. Tested succession refers to where you have a written will.
Wow, and I know most of our viewers are intestate.
Yes, of course, due to various reasons, and most of them cultural, where people generally fear death and what will happen to after death. Within our country, it's very rare to find someone who has written a will.
So in your own experience, is it that people fear death, or it's that they don't have the knowledge? Is it the fear? What is it?
I would say it is both lack of that knowledge, because even those who have that knowledge that you're supposed to plan what happens after your death, you will find still majority do not take that step to write a will or make arrangements of what will happen after their death.
Now, explain to us, like 2-year-olds,
yes.
When there is a will, yes, what is the procedure?
When there is a will, the procedure is, of course, you will have written a will, you will have appointed the executors or the people who will ensure what you have written in your will happens. So once upon your death, the first thing is that your executors or the advocate who wrote the will call your spouse, your children, and all those people who are entitled to your will, and inform them of the contents of the will. Then after that, what happens next is that that will has to be validated by the court. Okay, so the executors or the people you appointed have to file that will in court, so that the court confirms it through a procedure we call grant of probate, which literally means to confirm that the will, those are your wishes, the will meets the threshold, the legal threshold as required by the law. And once the will is confirmed, then your assets and your properties will be distributed as per how you distributed them in your will, or according to your wishes as you may have noted them in your will.
So after that process,
yes,
then it means that the new owners of the properties, yes, the documents will be transferred to their names.
Yes, yes. If you had land somewhere, shares, money in bank accounts, everything you will have identified in your will as your asset will now be transferred to those whom you had wished to be transferred to.
So assuming the will is not validated by court,
Yes.
it means that the will is contested.
Yes, yeah, yes. The beneficiaries, people, those are the people named in the will, or people, someone who is not named in the will as a beneficiary can contest a will, and there are several grounds upon which a will can be contested. One of the most common grounds is where the testator or the person making the will does not provide for, does not make provision for one of the beneficiaries. Say that, for instance, I have 5 children and 1 wife, and I have not provided for one of the children, and I have not assigned any reason. So I have only distributed my properties and assets to my wife and the 4 children, but left out the 5th children without any reason. So that is a ground for invalidation of the will. If the will was made under duress, coercion, that is also another ground. If the will was made by someone who was not of sound mind, if you are able to prove to the court that by the time that will was being written, the person did not have his mental faculties in order, that would also be another ground for invalidation. If the court now finds that the will was not valid, what now the court, the procedure now reverts to intestate succession. The court will proceed as if there was no will. Yeah.
Under testate, it can either be that we have a will or there's a trust.
Yes. Yeah.
Please tell us.
Yes, you can do your estate planning through a will or a trust. Then a trust is an arrangement between 3 individuals or 3 entities. There will be the person who is making the trust, or the person who owns the assets. Okay, that person is known in law as a settlor. Then we have the trustee, the person being appointed to manage the asset or the property. He is called the trustee. And then we have the beneficiary. This is the person for whom benefit the trust is made, and the person who will derive the benefit from the trust. So, and that arrangement is made through a document known as a trust deed. So you have to prepare a trust deed and then register it, then transfer the assets that you wish to plan under a trust to the trusts now. Okay, and once a trust deed is registered, it is incorporated, it becomes a separate legal entity from the owner of the property. So you no longer own the property. Then the trust deed will have provisions on how the income generated from the assets or the property will be shared by the beneficiaries. And the difference between a trust and a will is that a trust will take effect during your lifetime. Once you have registered a trust and transferred the properties to the trust, then it takes effect immediately. Unlike a will will only take effect upon your death and once it is validated by the court. Yes.
Well, I think it's very, very insightful, and it's important for our viewers to note that when you have properties or proceeds, you actually don't have to split the properties or the proceeds.
Yeah, you do not have you do not necessarily have to distribute. If you have, let's say, a building that is generating income, you do not have to say, you Kimani take first floor to second floor, or Udo take rent for the 3rd floor, and so on and so forth. You can simply register a trust, transfer the property to the trust, and then once the income is received by the trustee, then the trustee has instructions on what each and every beneficiary or each and every child is entitled from the income you are getting from the property.
And there's a way of succession planning for the trustees, assuming one of the trustees passes on.
Yeah, that is why we have a document called the trust deed. The trust deed will, among other things, provide for how the trustees are appointed, when there is a vacancy in the office of the trustee, how is that vacancy filled, so that at no given time there is a void or there is a vacuum in the way the trust is being administered.
Okay, before we come to the last question,
Yes.
something have come in my mind. Many times the will is written,
Yes.
but do we have instances where there is a verbal will?
Yes, there are instances where there is an oral will, and the law recognizes that one can make an oral will. The most important thing is that when you are making that oral will, there must be witnesses, because now it is not written. Even though the law requires that even where there is a written will, there must be also independent witnesses. Oral will, there also must be witnesses who can testify or affirm or confirm that you made an oral will and that you were of sound mind and you had the capability to make that oral will. So yes, oral wills are recognized in law. But of course, the best thing is to always have a written will.
Okay.
Yes.
My last question,
Yes.
what are the advantages of having either a trust or a will?
The major advantage is that there are likely to be no contests or fights after your demise, because whatever your wishes are written, and if they meet the criteria provided for in the law, they are valid. The second advantage is that you have you have freedom. You have freedom to, divide or distribute your property the way you wish to. Remember, if you have no written will or you don't have a trust, is now you are leaving your property either people to fight over it or for other third parties to decide on what happens to your property. But in case of a will, you will have made that decision. Another huge advantage for trust is that it has some tax benefits, and one that comes in mind now is that for the beneficiaries, any income derived from the trust, if you have a trust and one of your children is entitled to income from that trust, any sum up to 10 million, you do not pay income tax. And that is a huge benefit, because the rate of income tax is 30%. I mean, if you can avoid paying tax of 3 million on an income of 10 million, that is a huge benefit.
Wow.
Yeah.
Thank you so much, Wakili.
You are welcome.
We are very well informed. I know this is one of the topics that viewers have been sending to my direct inbox.
Yes.
And I'm happy that we've addressed it. And I believe that our viewers are very well informed. Thank you, viewers, for watching today's episode. See you in our next video.
You're welcome.